Also this morning, Donald Trump hitting the campaign trail on a day off from his criminal trial here in New York. In court yesterday, the former president was held in contempt, fined $9,000 and threatened with jail time for his repeated violations of the gag order in the case. On the stand, jurors also heard from the lawyer who helped broker hush money agreements for Stormy Daniels and Karen McDougal over their claims of affairs with Mr. Trump just before the 2016 election. And all of this, of course, amid the backdrop of those campus protests just blocks away. We've got Laura Jarrett here, as you can see. We've got Peter Alexander as well. We'll get to the trial in a moment. Laura, let's talk about what we're seeing. This is leading every single newscast. You see this chaos on college campuses. The president, as I understand, former President Trump, calls into Fox News, sees a moment here, sees a political advantage here.
Well, that's exactly right. And for Democrats, there is a real fear of protest backlash right now. Privately, among Democratic lawmakers, they are sharing videos and pictures.
Hey guys, welcome. Adam is here, so this is just happening, guys. A judge told a sitting president directly, "Defy my order and you personally go to jail. Not your lawyers, not your staff, you. Handcuffs, a cell." And Trump stood up, turned away from the bench, and walked out mid-proceeding while his legal team was still arguing, Secret Service scrambling around him. He simply could not stay in that room for one more second. This is not a television drama. This is not a hypothetical scenario being floated by legal analysts on cable news.
Of what's happening on these campuses across the country right now. And this is an issue that really sort of demonstrates the divides within the Democratic Party. So that's the real concern for them. Think about this. This started at fundraisers and at speeches, including those done by the president. Now it's at campuses across the country. And the more the focus is on issues like this right now, this chaos that Donald Trump wants to amplify, much like he did about the same chaos we saw after the death of George Floyd in the summer of 2020 before the last election, it takes away from the issues the Democrats want to be talking about. Issues like reproductive rights, issues more broadly about health care, and frankly about the alleged crimes committed by Donald Trump himself.
Well, I know there's a concern also that it depresses Democratic turnout because there's this divide, but there's a certain irony because if the people that are upset about the Biden administration's Gaza policy stay home, then you're going to have former President Trump.
This happened in a D.C. courtroom with federal judge James Boasberg presiding, and the White House immediately descended into a state of absolute panic that insiders are now describing to journalists in terms that suggest genuine institutional terror. Not anger, not defiance, not the combative energy that has characterized every previous Trump confrontation with the judicial system. Fear, frozen, incapacitating.
Who is more hawkish on Israel than President Biden.
Yeah, no, you're exactly right on that issue in particular. And that is one of the concerns, is the potential for a depressed turnout among young voters right now. That's why you're really hearing the urgency privately and publicly from the administration right now for a diplomatic breakthrough as it relates to the situation between Israel and Gaza, with talks ongoing in that region. We heard from the national security spokesperson saying right now, in effect, that there has to be this deal. This deal has to happen now. They recognize the need to get this done, and they hope that a breakthrough could simmer some of these tensions.
Let's talk to Laura about the trial. So it's an off day. On every Wednesday is an off day. Yesterday, the former president was held in contempt by the judge for repeated violations of the gag order, and the judge kind of gave a shot across the bow.
Decision paralyzing fear. The president who built his entire political identity on never backing down, never showing weakness, never admitting vulnerability, is reportedly so frightened by the prospect of incarceration that his own staff is leaking to the media about his mental state. He is terrified of the handcuffs. That specific phrase, the handcuffs, is what keeps surfacing in accounts from people who have spoken with him directly. The physical reality of restraint, of confinement.
He said to him, look, if you keep doing this, I'm going to have to exact a more serious punishment. And the only other punishment available to him, other than a $1,000 fine, is jail time. He's made it clear he doesn't want to do that. He recognized in his order there are First Amendment concerns. He realizes he's dealing with the Republican frontrunner. But if he doesn't do what he would do for any other defendant, he's going to look ineffectual. And I think that's the tension that the judge is experiencing right now. And this is not even over. We're going to be back in court tomorrow with more alleged violations of the gag gag order, more different statements that the prosecution is asking him to be held in contempt of again.
This gag order is kind of like a little mini trial that's going on. Meanwhile, as for the trial, we had a lawyer on the stand yesterday who was privy to these negotiations and the payments to the porn star, to Stormy Daniels and to Karen McDougal, who alleged that she had had a relationship with the former president.
He was there to try to take the jury
of being treated like someone who is subject to the law rather than someone who operates above it. The timing of this judicial earthquake could not be more devastating for a president already reeling from a cascade of crises that have converged into a single overwhelming political storm. Earlier that same day, the Supreme Court delivered a 6-3 ruling against Trump's position on the National Guard deployment case, a decision that clipped his claimed emergency powers so definitively.
Inside how all of these payments actually started, right? Last week, we heard how Donald Trump was in the room for the alleged plot as they were talking about catching and killing bad stories. Well, then now we're actually in the moment where the hush money is being transferred over to Stormy Daniels. But we are yet to be at the point where we understand Donald Trump's connection to any of this. We've heard a lot about Michael Cohen. We have not heard as much about Donald Trump.
And you pointed out, I mean, these are hush money payments that on their terms are not illegal. The issue is whether or not business records were falsified.
Yes, it's all about the cover-up.
And is
for
that
prosecutors.
Right. Have prosecutors, they're not there yet.
No.
Are they getting there?
That's the question, is whether the jury is getting enough to understand where they're going and whether they feel like their time is being wasted. That's always a balance for these cases.
That even the conservative justices he appointed refused to endorse his legal theory. So the highest court in the land rejected him, and then hours later, a federal district judge threatened him with personal incarceration. That is a 1-2 punch that would stagger any human being, and it clearly staggered Trump in ways that were visible to everyone in that courtroom. He could not sit still. He could not maintain the facade of confidence. He had to get out of the room, retreat to Air Force One, and fly away from the physical location where a judge had just told him that the law applies to presidents too. What specifically triggered this extraordinary confrontation is the Epstein files, those documents that Trump has been fighting to keep sealed and redacted through every legal maneuver his team could devise. Judge Boasberg has been presiding over the ongoing battle regarding what Trump knew about Jeffrey Epstein, and when he knew it, what documents exist in government files that would clarify the exact nature of their relationship, and why the administration has been so desperately determined to prevent those documents from seeing the light of day. Trump's legal team has deployed every delay tactic available in the federal procedural arsenal: executive privilege claims, national security concerns, the need to protect the identity of confidential sources, arguments about the safety of federal agents, creative interpretations of classification protocols, last-minute appeals filed at the 11th hour. Every trick that skilled litigators use when their actual goal is not to win on the merits, but simply to run out the clock has been deployed in this case. And for a while, the strategy worked. Judges granted extensions. Deadlines got pushed back. The documents stayed hidden. But Boasberg finally reached the limit of his patience and decided that the game was over. In open court, with C-SPAN cameras recording every word, the judge issued an oral ruling that was stunning in its directness and its specificity. No more delays, no more extensions, no more creative legal arguments designed to buy weeks or months while the documents remain under seal. The Epstein files are to be released unredacted by Monday. That is the deadline. That is the order. And if the president attempts to stall again, if he files another appeal, if he claims another privilege, if he deploys another procedural technicality to push the release date further into the future, then contempt charges will follow. Personal contempt, meaning the president himself, not some subordinate who can be offered up as a sacrificial lamb, will face incarceration. Coercive custody is the legal term, the mechanism by which federal judges enforce compliance with court orders by holding the defiant party in jail until they decide to follow the law. Boasberg did not say this might happen. He said it will happen. No ambiguity, no wiggle room, no face-saving escape clause that Trump's lawyers could exploit in subsequent filings. Comply or go to jail. Those are the options. Trump's reaction to hearing this threat delivered directly at him not through lawyers or press statements, but from a federal judge looking at him across the courtroom, was so visceral that it overwhelmed whatever political instincts usually govern his public behavior. He got up and left. The Secret Service rushed him out through a side exit. He was taken directly to Air Force One. He did not hold an impromptu press conference on the courthouse steps to denounce the judge and rally his supporters. He did not post defiant messages from his phone while still inside the building. He physically removed himself from the environment where the threat had been delivered because staying there meant continuing to absorb the reality of what a federal judge had just said to him, and that reality was apparently more than he could process while sitting in a chair in public view. The optics were catastrophic, and everyone in the White House knows it. The image of an American president fleeing a federal courtroom after being threatened with jail is the kind of visual that defines historical narratives. It will be in every documentary, every retrospective, every textbook chapter about this period. It is the photograph that captures a presidency in freefall. The insiders who are now talking to journalists are painting a picture of a president in genuine psychological crisis. Frozen in fear is the phrase that keeps appearing in multiple accounts from different sources. He is not strategizing his way out of this. He is not working the phones to rally congressional allies. He is not coordinating with his legal team on the next procedural move. He is panicked, genuinely and deeply panicked, and the specific focus of that panic is the physical reality of incarceration. The handcuffs, the loss of control, the transformation from the most powerful person on the planet into someone who is told when to wake up and when to eat, and where to sit and when to speak. For a man whose entire psychological makeup is organized around dominance and control, and the projection of invincibility, the prospect of being physically restrained and confined is not just a legal problem to be solved. It is an existential threat to his sense of self. And that threat has now been made explicit by a judge who clearly intends to follow through. The true social posts that followed were classic Trump in their presentation but revealing in their subtext. Rigged judges, deep state conspiracy, they want me in chains. The familiar vocabulary of persecution and victimhood deployed at maximum volume. 12 million views on the latest post, the audience as large as ever, the engagement metrics still formidable. But underneath the bluster and the capitalized rage, the panic is visible to anyone who knows how to read the signals. He is not dismissing the threat as absurd or impossible. He is treating it as real because a federal judge just made it real. And he is trying to rally his supporters against something that has now moved from the realm of political rhetoric into the realm of imminent legal consequences. The Epstein mentions are a critical piece of this puzzle that Boasberg specifically highlighted in his ruling. The judge noted that Trump has referenced Epstein publicly 15 different times over the years, in various contexts and with varying degrees of proximity and distance depending on when the question was asked. To the judge, this pattern of public statements is not mere coincidence or idle chatter. It is direct evidence of a deliberate strategy to obstruct the investigation and delay the document release. Every time Trump makes another Epstein comment, every time he claims not to have known him well or distances himself from the relationship, or attacks the credibility of people asking questions, he is demonstrating a consciousness of the issue that undercuts his legal team's arguments about why the documents cannot be released. You cannot simultaneously claim that the documents are irrelevant and that releasing them would cause catastrophic harm. You cannot argue that there is nothing to hide while fighting so ferociously to keep everything hidden. The contradiction is glaring, and Boasberg has apparently concluded that the only reasonable explanation for Trump's behavior is deliberate obstruction. That conclusion is what transformed the judge's warnings from the general to the specific, from the hypothetical to the immediate. The broader context surrounding this courtroom drama makes it exponentially more dangerous for Trump politically because it is not happening in isolation. The Supreme Court ruling earlier that same day was a devastating rejection of his theory of presidential power, a 6-3 decision that signaled even the conservative justices have limits on how far they will go to accommodate his claims of unchecked executive authority. The Pam Bondi situation exploded when it emerged that her client list, The credential she presented as justification for her appointment as Attorney General was apparently exaggerated or fabricated, and Trump responded by calling her a liar on the record. The president publicly attacking his own hand-picked Attorney General pick for dishonesty about her qualifications. GOP members in Congress voted against Trump's position on Iran war powers, a Republican rebellion on national security that would have been unthinkable in the early years of his political dominance. Cabinet members are openly revolting over the Iran military planning, with leaks and criticisms surfacing from inside the administration itself. The approval rating sits at 35%, historically abysmal for a sitting president at this stage, while 62% of Americans tell pollsters that Trump defies the courts too often. Every pillar of political support is cracking simultaneously, and then a federal judge threatens him with jail and he walks out of the courtroom on camera. The legal mechanics of what Boasberg actually did are important to understand because they explain why this threat is fundamentally different from the rhetorical warnings Trump has been receiving for months. Coercive contempt is a specific judicial tool designed for exactly this situation. When a party to a case is willfully and deliberately disobeying a court order, the judge has the authority to incarcerate that party until they decide to comply. This is not punitive contempt, which is a punishment for past disobedience. It is coercive contempt, which is a mechanism for producing future compliance. The judge is not saying you will go to jail for what you have already done. The judge is saying you will go to jail until you do what I have ordered you to do, and the moment you comply, you can be released. The keys to the jail cell are in your own pocket. All you have to do is follow the law and the confinement ends. That is what makes this threat so immediate and so difficult to evade through normal appellate procedures. You cannot appeal a coercive contempt order the way you can appeal a final judgment. You are sitting in a cell while your lawyers file papers, and those papers take time, and the whole time you are sitting there. Boasberg did not make this threat casually or speculatively. He made it after documenting 15 separate instances of Trump publicly discussing Epstein, after watching the administration exhaust every delay tactic available, after concluding that the pattern of behavior demonstrated willful obstruction rather than legitimate legal disagreement. When a federal judge reaches that conclusion and articulates it in open court, the dynamic shifts from legal negotiation to judicial enforcement. The judge is no longer asking nicely. The judge is no longer granting extensions while hinting that patience is running thin. The judge is issuing an ultimatum with a specific deadline and clearly stated consequences for non-compliance. Monday, unredacted documents or contempt proceedings begin. That is not a suggestion. That is not a starting point for further negotiation. That is an order backed by the coercive power of the federal judiciary, and Trump just heard it delivered directly to his face. The ripple effects through Trump's inner circle are potentially even more destabilizing than the direct threat to Trump himself. Everyone who works for the president, every lawyer advising him, every staff member involved in document decisions, every ally who has helped implement the delay strategy, is now looking at this ruling and recalculating their own personal exposure. If a federal judge is willing to threaten the president with jail, what happens to the people around him who are not protected by the institutional deference that still partially shields a sitting president? What happens to the lawyers who signed the filings advancing arguments the judge has now characterized as obstruction? What happens to the staff members who executed the document withholding decisions? The cascading effect is predictable and devastating. People start thinking about their own futures. People start wondering whether loyalty to Trump is worth the risk of becoming collateral damage in a judicial crackdown. People start making quiet phone calls to their own attorneys, asking about cooperation agreements and immunity deals, and what happens if they decide to tell prosecutors everything they know. This is how organizations unravel under legal pressure. It starts at the top with the principal being directly threatened, and then it works its way down through every level as individuals calculate that protecting themselves is more important than protecting the boss. Trump understands this dynamic intuitively because he has spent his entire career operating in environments where loyalty is transactional and everyone is ultimately looking out for themselves. The panic that insiders are describing is not just about his own potential incarceration. It is about the whole structure of protection collapsing as people inside start defecting to save themselves. The fear of the handcuffs is real, but so is the fear of being the last person left standing when everyone else has already made their deals. The political implications for congressional Republicans are immediate and severe. When a sitting president is threatened with jail by a federal judge on the same day the Supreme Court rejects his constitutional arguments 6-3, the electoral calculus for every Republican member in a competitive district shifts dramatically. Do you want to be the candidate running for re-election while your party's president is fighting a contempt order? Do you want to be explaining to suburban voters why you voted to protect a president who fled a federal courtroom after being told he could go to jail? The 7 votes that have protected Trump's war powers authority in the House, the 16 votes in the Senate, those margins were already razor-thin before Boasberg dropped his bombshell. Every additional day of legal chaos makes those votes harder to hold. Members start thinking about their own careers. They start calculating whether distance from Trump is the safer political position. They start wondering whether the president they have been defending is going to be in jail when their re-election campaigns begin. The Monday deadline creates an immediate pressure cooker with no escape valve. Either Trump complies with the order and releases the Epstein documents, which will contain whatever they contain and trigger whatever political consequences follow from full disclosure, or he defies the order and triggers contempt proceedings that could result in the first incarceration of a sitting president in American history. Those are the options. There is no third path. There is no clever procedural maneuver that makes the whole thing go away. There is no delay tactic left in the arsenal that Boasberg has not already rejected. The judge has drawn a line and set a clock, and every hour that passes between now and Monday increases the pressure on everyone involved. If Trump releases the documents, he survives the immediate threat, but absorbs whatever political damage the contents produce. The underlying problems do not disappear. The Supreme Court loss still stands. The approval rating still sits at 35%. The congressional Republicans still voted against him on war powers. The cabinet revolt is still simmering. The Bondi embarrassment still undermines his claims of competent leadership. But he avoids jail for now, and that may be the only calculation that matters at this moment. If he defies the order, he enters genuinely uncharted constitutional territory. The Secret Service is legally obligated to protect the president, but the Marshal's Service is legally obligated to enforce federal court orders. What happens when those obligations collide? Nobody knows because it has never happened. Does the cabinet invoke the 25th Amendment and declare the president unable to discharge his duties while incarcerated? Does Congress move immediately on impeachment and removal? Does the military issue any statements about chain of command? The scenarios are the stuff of constitutional law hypotheticals that professors pose to first-year students as thought experiments, not as imminent possibilities. Trump's retreat to Air Force One was symbolic in ways that transcend the immediate legal situation. The president fled to the one place where federal judges cannot reach him, the aircraft that symbolizes presidential power and mobility and escape. But the deadline is still coming. Monday is still on the calendar, the documents must still be released, and the judge who issued the threat is still sitting in his courtroom, waiting to see whether the President of the United States will comply with a direct order or force the judiciary to take a step that has never been taken before. The walls are closing in from every direction. The Supreme Court has spoken. Congress is fracturing. The cabinet is leaking. The approval rating is cratering. And now a federal judge has looked the president in the eye and told him that the law applies to everyone, even the person sitting in the Oval Office. The panic is real because the threat is real, and the clock is ticking toward Monday with no indication that anyone in the White House knows what to do next.